Welcome back to The Explainer. So today we're unpacking a truly fascinating case study from the Constitutional Court of South Africa. It perfectly captures what happens when extreme business desperation just crashes headfirst into strict constitutional procedure. We're looking at a landmark judgment from 1998, Bruce versus Fleecytex, delivered by President Chaskalson. Guys, this is literally a masterclass in the mechanics of justice, and it shows exactly why the rules of the court matter just as much as the rights you're actually trying to protect. Right, let's dive into this. We really need to talk about why Hollywood's idea of taking a case all the way to the top isn't exactly how the justice system works. You know the movies, right? The hero is facing impossible odds, so they storm past the local judges and demand a hearing before the Supreme or Constitutional Court to get immediate justice. It's dramatic. But in reality, the judicial system is built as a careful hierarchy for a very specific reason. And this explainer is going to show you exactly why attempting to skip the queue usually results in a firm judicial roadblock, no matter how incredibly urgent your crisis feels. Okay, Section 1, the baby angel liquidation. We start our story in late 1997. We've got Elmarie Bruce, a desperate business owner fighting with absolutely everything she has to save her company, a close corporation named Baby Angel, from total liquidation. And you can really feel the sheer panic of the situation when you look at how fast things were moving. On December 4th, 1997, the High Court ordered Baby Angel into liquidation. On that exact same day, an application for leave to appeal was filed. Now, Bruce thought this appeal would just freeze everything, right? Allow her to keep running her business, but nope. The liquidator aggressively pushed forward to wind up the company anyway. Panicking, Bruce rushed back to the High Court on January 23rd for an urgent interdict to stop the liquidator. She lost that round. And then just 6 days later, on January 29th, she bypassed the normal appeals process entirely and applied directly to the Constitutional Court. Now, you might be wondering, wait, why didn't her initial appeal just freeze the liquidation? Well, the major roadblock Bruce hit was this specific rule, Section 153 of the Insolvency Act. Normally, under standard court rules, when you appeal a decision, the execution of that decision is suspended. It basically hits the pause button. But Section 153 creates this really harsh exception for insolvencies. It explicitly states that even if you appeal a final sequestration or liquidation order, the liquidation process just keeps going as if no appeal had been noted. So for Bruce, this literally meant the liquidator could keep dismantling Baby Angel right in front of her eyes while she sat around waiting for her appeal. Moving on to Section 2, skipping the legal line. Facing the immediate loss of her business and watching her life's work get dismantled piece by piece, Bruce decided she just couldn't wait for normal procedures. She attempted a massive judicial shortcut. The crucial point here is that she tried to jump the line, claiming her situation was way too urgent for the standard legal machinery. She tried to use a mechanism called direct access, which is governed by Rule 17 of the Constitutional Court Rules and Section 167(6) of the 1996 Constitution. Direct access is kind of like a highly restricted VIP pass that lets you skip the lower courts if the interest of justice absolutely demanded. Bruce argued that if she had to wait for the standard appeal courts to hear her case, her company would be entirely liquidated by the time she won. The whole purpose of the appeal would be totally defeated. So, she asked the Constitutional Court directly to declare Section 153 unconstitutional, arguing it violated her right of access to the courts and her right to trade freely. But here is the really interesting part, and it's a critical procedural error. She assumed only the highest court could save her. When Bruce appeared before Judge Wunsch in the High Court just days earlier to ask for that urgent interdict, she never even brought up the constitutionality of Section 153. She or her legal counsel seemingly just assumed that a high court judge was bound to blindly apply an act of parliament exactly as it stood. So they figured arguing constitutional rights in that lower court would be a total waste of time. They genuinely believed that only the Constitutional Court possessed the magic wand to strike down the law and halt the liquidator. Which brings us to Section 3, the rules of direct access. So that assumption Bruce and her team made, it was based on a fundamental misunderstanding of how constitutional power had actually evolved in South Africa. Under the new 1996 rules, the High Court already had the exact power Bruce thought she needed to go to the top four. Now, actually, if this case had happened just a few years earlier under the interim constitution, Bruce might have been right. Back then, only the Constitutional Court had the jurisdiction to strike down an act of parliament, but Bruce was operating under the final 1996 Constitution. As President Chaskalson pointed out in his judgment, under the 1996 Constitution, high courts were granted broad constitutional jurisdiction. They can look at an act of parliament, declare it unconstitutional, and this was absolutely crucial for Bruce, grant temporary interdicts and relief to protect people while the Constitutional Court reviews the final invalidation. So instead of skipping the line, there was a proper, standard procedural path she should have followed to get the emergency relief she so desperately wanted. When she was standing in front of Judge Wunsch in the High Court, that's step 1, she should have argued that Section 153 was unconstitutional right then and there. If the judge agreed, we moved to step 2. He had the power to grant her a temporary interdict, stopping the liquidator dead in his tracks. Finally, in step 3, the matter would systematically make its way up to the Constitutional Court for final confirmation. She didn't need direct access for an emergency fix, she just needed to use the powers the High Court already possessed. And because she failed to raise it there, she was essentially trying to use direct access as a sneaky, backdoor way to appeal Judge Wunsch's decision without following the rules. All right, Section 4, Why the Process Matters. Faced with this attempted procedural shortcut, the Constitutional Court, led by President Chaskalson, had to step in and deliver a very firm judicial reality check. They used this case to clearly draw the boundaries of their jurisdiction. The highest court emphatically stated that it cannot be both the first and the only place a case is heard. I want you to really think about this quote from the judgment. Jurisprudential policy dictates that this court should ordinarily not deal with matters as both a court of first instance and as one of last resort. Basically, the Constitutional Court is designed to be the ultimate ceiling of the justice system, not the front door. If you bring a case directly to them, they become the very first people to hear the facts, and because they are the highest court, whatever they decide is absolutely final. And these points explain exactly why direct access is so heavily restricted. The highest court needs the foundation that lower courts provide. The court outlined several massive dangers of just letting people bypass the system. First off, the Constitutional Court is an appellate body. They aren't set up to hear raw witness testimony or resolve deeply disputed facts. That's a trial court's job. Second, if they take cases directly, they might end up wasting time deciding constitutional issues that turn out to be purely academic, stuff a lower court might have just resolved on standard legal grounds without even touching the Constitution. Third, they'd be totally deprived of the valuable legal reasoning and the refined arguments that come from High Court and Supreme Court of Appeal judges debating the issue first. And finally, and this is a big one, if the Constitutional Court makes a mistake as the court of first instance, the losing party has absolutely nowhere else to go, no possibility of appeal whatsoever. It's a huge risk to justice. Ultimately, this highlights the core philosophy of the whole justice system. The legal process is designed for refinement and accuracy, not just speed. President Chaskalson notes that a losing party in a lower court gets the chance to read the judge's reasoning, figure out exactly where their argument was weak, and refine it for the appeal. The law literally gets sharper, clearer, and more accurate as it moves up the ladder. The Constitutional Court absolutely relies on that sharpened, refined argument to make the best possible constitutional decisions for the entire country. Bruce was basically trying to force them to make a snap judgment in a vacuum, which they firmly refused to do, dismissing her application for direct access. So, as we wrap up this explainer, I want to leave you to ponder this. Are these procedural hurdles really just annoying red tape, or are they actually the very structures protecting our rights? Elmarie Bruce saw the High Court and the appeals process as this slow, bureaucratic nightmare that was going to ruin her business. But the Constitutional Court saw those exact same steps as the indispensable machinery that ensures every single ruling is rigorously tested, factually sound, and ultimately just. By demanding that litigants follow the proper path, the court isn't just protecting its own schedule, it's protecting the integrity of the law itself. Thank you so much for joining me to unpack these vital lessons from Bruce versus Fleecytex. Keep questioning, keep learning, and I will catch you in the next explainer.